Hello and welcome to the eighth lecture in our module entitled Fight Against Corruption. And I'm Elnur Musayev, teacher at Criminal Law and Criminology Department of Baku State University. I'm teaching this module at the postgraduate course. And this lecture is entitled Incrimination of Corruption in Public Sector in Azerbaijan. This is fourth lecture out of fourth dedicated to this specific topic of public sector corruption in Azerbaijan, and we speak about it in the context of incrimination. And our traditional slogan, our traditional message for these times, as I'm teaching this in spring 2020, stay at home, be optimistic, and don't waste your time in the colors of our flag, blue, red, and green. I hope you take benefit of this time and study eagerly and increase your knowledge, and I hope time spent on listening to my lectures will bring you some use and benefit. The content is traditional. I'll provide you the general context that our topic fits in. This will be the general topic. Then we will kind of slightly go through these previous lectures. We will cover substantial and significant issues. Then we will move on. We will move on to the issue of. We'll cover specific issues, and we'll cover specific concept. Then we will look at national legislation and see what's left there, what is left there, and let's start with our general context. So as you know, as I said it on numerous occasions, no single definition of corruption. It's just covered in it's just a series of offenses which are prescribed or offered by the international instruments which are included in national legislation. Corruption, as you know, is dealt with in the country according to the UN model. So it's different areas, it's dealt with at different tiers. Prevention of corruption and then law enforcement measures of corruption, against corruption, international legal assistance in this field, asset recovery, and now we're dealing within the second broad topic of criminalization of corruption. The approach undertaken by Azerbaijani side is to cover corruption offenses as much as possible, and in this regard to follow the lead of international instruments. And as you know, these international instruments are United Nations Convention Against Corruption and European Criminal Law on Corruption. So the extent, the manner in which the corruption offenses are handled, it also is in line with this international approach. When the countries, when the legal community try to use the kind of terms which are broad in nature, they're not exhaustive in their understanding, as the corruption has to develop as the society develops, and it has to respond to modern challenges. We covered such issues as offer, promise, acceptance, and solicitation as necessary elements of corruption and specifically bribery offenses. And we have noted that it's crucial that the benefit out of which emanates from corruption offenses, it does not necessarily goes to the perpetrator or a public official, as the more and more sophisticated financial tools and institutional tools which allow corrupted public officials to conceal their illegal incomes. Therefore, anti-corruption legislation has to be in line with these modern developments, and it has to foresee all sorts of these vehicles which allow and facilitate criminals to hide their goods. Undue advantage is a concept according to which it's a subject matter, actually, the thing around which these all corruption offenses are involved. This is the incentive for corrupt behavior, and it is qualified as anything tangible, intangible, material or immaterial, in a sense this which brings the perpetrator in a better position than he or she used to be prior to committing this offense. And property in some of the offenses, such as embezzlement and misappropriation or diversion, we use terminology among the terms the concept of property, which is also quite wide and broad in its definition, and it covers tangible, intangible, material, immaterial, corporate, incorporate type of property, as well as legal documents supporting title to some other specific property. We spoke in abundance about specific offenses of bribery, whether active or passive, and embezzlement, which also covers the offenses of misappropriation and diversion. Then we also covered such offenses as abuse of office and trade in influence. And trade in influence as well, active and passive one. Let's now look at just remind ourselves how United Nations Convention Against Corruption treats this public sector corruption offenses through this set of articles. Of course, there are other articles as well, but we will concentrate on these specific ones. The situation at the domestic level is that, as you know, mostly the corruption offenses are concentrated in Chapter 30, except for one offense, which is, as you see, Section 314, negligence. Except for this, all of these offenses in Chapter 30 are corruption offenses, and we covered you can see these covered offenses in yellow color. This is abuse of office, passive bribery, active bribery, trade in influence. And apart from these specific offenses, corruption offenses in Chapter 30, there are also corruption offenses in other parts of the Penal Code. And one of them which stands out is embezzlement and diversion, as you can see in Section 179 of the Penal Code. Actually, it is classified as a crime against property. And there are many other crimes, and I said this before in our previous lectures, other crimes which can be perpetrated by public officials, and in the national legislation it's expressed in a specific term by making use of his powers or duty of official position. There are more than 60 such crimes in the Penal Code. So in a sense, in a wider sense, they're also considered as corruption offenses, but we will not go as far as to look at all of them. We will just try to limit ourselves with these significant ones, which you see on the screen for now, and some others which I will mention later. So let's start with a specific offense of reflected in Penal Code Section 308-1, which is entitled as diversion of public funds. Diversion of public funds, and Mens rea is as usual. The full name of this section is deviated usage or diversion of budget, public special revenue funds and extra budgetary fund capital. That's a long and the correct, the most precise name of this section. And here I try to take on this, show as much as possible the original terms used in the text itself. Mens rea of this offense is intention, direct intent, and you perfectly know by this moment that only the direct intent form of guilt is applicable to corruption offenses. Actus reus, the objective side of this offense. We will look first at the perpetrator is public official. Modus operandi is actual diversion of capital. So some public official has to exercise his duties in order to divert. He has to exercise his powers to divert certain funds, and you can see that three different sources of funds are identified in the title of this section, which actually encompass all the so-called state or public funds in this country. Beneficiary, it hasn't to be shown, which actually facilitates or makes it easier the work of the investigation and prosecution, so they don't have to prove that the perpetrator is seeking some sort of advantage, or they don't have to build this link. Okay, in a sense, if you look at this section, it is very close to diversion and misappropriation, and the difference here is that it has less elements than this original embezzlement and misappropriation crime in section 179. Here what you need to show is that there's some funds which qualify to a certain value, and in this case it is 50,000 manat, the local currency, which makes about 25,000 euros at the moment. Once you can demonstrate, once investigation or prosecution can demonstrate that this amount of capital, of funds, were diverted or used not according to its main purpose, then it is enough to pursue the investigation and prosecution, and you don't have to investigator or prosecutor they don't have to prove anything else, no other elements as to where this money went and what they do. So this is let's look at the at where this crime is located in the among other crimes in the classification of crimes. And let me remind you that crimes are classified according to 4 grades, according to the level of their gravity, starting from the misdemeanor type of offense up to felony. So in Azerbaijan, the misdemeanor or the lightest form of crime would be entitled crimes of not big public danger, shortly seen BPD. Then comes less serious crimes. After that, we're dealing already with the serious crimes, and the felony is in Azerbaijan is entitled by the term of especially serious crimes. They are classified and distincted according to the sanctions, and there's a certain level, a threshold, which allows to differentiate between these categories of crime. Thus, for this first category, first grade of crime, it's up to 2 years imprisonment, and for the less serious crimes, it's 7 years of imprisonment. Serious crime is up to 12 years of imprisonment, and above that, including the strictest sanctions in this country, the life imprisonment. They are considered especially serious crimes, and this classification has bearings not only in terms of sanctions but also on the term of statute of limitation, term of investigation, preliminary or pre-trial investigation, term of length of custody at the pre-trial stage, and some other issues as well. I'm not going into detail, as this belongs to other discipline of criminal procedure, and you studied many of these aspects at the undergraduate level in your module on criminal law. Let's see where this specific section of diversion of public funds is within the system of grades and classification of offenses. The typical type of diversion of public funds offenses, this is section 308-1. It's considered a less serious crime. And it is actually the punishment for this offense is strict, up to 7 years. So one should not consider this as a sort of a getaway possibility with a lighter punishment as an alternative to section 179, because it starts with a much harsher punishment than that section 179. And the condition for differentiating between different types of this offense is according to a size of the capital that was misused. Okay, sorry, I apologize for that. I haven't mastered yet all these opportunities for managing this recording, so I didn't have a chance to miss this sneezing. The next type, more grave form, it's also considered less serious crime, up to 7 years. Again, as I said this, and I mentioned this with regard to previous to other types of offenses. Here the punishment and sanctions are different. Okay, in a basic form of this offense, the punishment is lesser than in the aggravated form. An aggravated form, it's actually 7 years, the top punishment, but it doesn't start from. The sanction starts where the previous one ends. In accordance with the requirement of the United Nations Convention Against Corruption, which prescribes that countries shall take into account the level of gravity when they assign the punishment for different type of offenses. The next one is PC section 308-2. In short, it's entitled Breaking Public Procurement Rules. But its full name, if you want to know exactly, it's spending of state funds without public procurement, or illegal conducting of public procurement. These two are actually very specific offenses which were formulated in view of concerns and in line with the situation which was taking place at the time. The number of the offenses in this area and the way the difficulties with the investigation and prosecution, they actually inspired the legislator to adopt this legislation. Mens rea is, as usual, in direct intent, as no other forms of guilt are allowed for the corruption offences. Actus reus, the perpetrator is public official, naturally, and incentive, it doesn't need to be shown. So it's not necessary for the investigation or prosecutor to demonstrate what kind of incentive there was. And this is not out of the desire of these authorities, but it applies to the cases when they might not be able to actually prove and link some sort of benefit with a public official. It's a kind of safety net for a investigation and prosecution. If they would manage to show this undue benefit, of course they will go for other types of crime like abuse of office or bribery. But in this offense, in order to build all the elements of this offense, it's not necessary to demonstrate that public official was pursuing some sort of incentive. Modus operandi is breaking of various rules, and beneficiary doesn't need to be shown. It's just the person, a public official. The investigation and prosecution, they have to demonstrate that certain person was in charge of breaking these public procurement rules, and that they do not follow the rules, and as a result the legislation which regulates these public procurement rules is broken. And here I want to just expand a little bit on what the public procurement rules are. As you know, there are many rules which govern the transparent and competitive nature of public procurement. The public procurement rules have to be just, impartial, so that they would allow, as they're destined, to provide the state with the best goods and services through fair competition. In order to secure this, there should be special tender procedures followed. Goods must certainly be bought from multiple sources, i.e., the tender shall be allowed with sufficient times for bidders to apply. The competition must run in a transparent manner without IDs known to the impartial commission, which will have to select the winner, and specifications must be announced before time, and the parties, these specifications must be reasonable. Sufficient time must be allowed for the submission of bids, and the consideration review of the bids must be unanimous. The commission shall not know who is actually bidding for this type of contracts on the supply of goods and services. And these different kind of requirements, only in very exceptional circumstances single source procurement should be allowed. So this vast body of legislation in this field which has to be followed. So if any state institution or public official, specifically if he conducts this public procurement without he obtains some goods without public procurement procedures, or he conducts it in a illegal way, he breaks the rules, in that case he is actually breaking the law and is committing this offense. And the condition and as well as the consequence which has to be established is that 50,000 manat worth, above 50,000 manat worth capital have to be expended. Before that, it's a different type of offense. If it's below 50,000 manat, it probably will run into the area of administrative law, which again is not subject matter of our lecture today. Let us look at the classification of crimes, again 4 grades of crime divided according to their sanctions, specifically the years of imprisonment. So section 308-2, there are only 2 types of this offended, one basic form and one more grave form. The first category is when the capital between 50,000 manat and 250,000 manat is expended, used. This is crime of not big public danger, up to 2 years of imprisonment. And the next one, more grave one, is when it's above 250,000 manat capital, and it's a less serious crime with up to 7 years of imprisonment as a sanction. I hope you understood properly the essence of this offense. This money, this big sum of money of up to like 50,000, up to 250, and above that 250,000 manats, they do not disappear. Okay, if they do not disappear and you find out that they were used to purchase this the goods, and the goods are there, then in this case it will be qualified as this offense. It will be qualified as this offense. But if money are gone and there are no goods, then it would be a different offense, right? And it would be misappropriation and embezzlement. It would be a totally different offense committed, 179, section 179. In this case, it's only about manipulating of these public procurement rules when they are actually giving the bids for these unscrupulous public officials are giving bids to their connections or abusing these powers. Okay, so it doesn't have anything to do with the misappropriation or diversion. The next one is the excess of power. Excessive power, it's again, it shall be committed, or it can be committed rather, with a form of guilt of direct intent. And the actus reus is perpetrated by a public official. It has to be conducted in an active way through the action, and its modus operandi is explicit excess of authority. Okay, you see here that I highlighted the word explicit, and it's highlighted in the text of the law as well. Naturally, there is a room always room for some sort of deviation from the borders of the official duty, and sometimes it might not happen intentionally. So public authorities, public officials, they can excess their duty to a certain degree. Of course, that doesn't mean that it's impune, that they will not be punished for that. There are other forms of punishment and sanctioning for these type of violations, most likely in the field of administrative or disciplinary proceedings. But when it's explicitly in excess of authority, and it can be proved, so there's a subjective element to this concept, when there is a possibility to show that there is an explicit excess of authority, then this offense comes into play. Incentive doesn't need to be established in this offense. Beneficiary as well, the investigation and prosecution doesn't have to demonstrate that actually public official benefited in some way from this action. If he did actually, if he benefits, if investigation manages to show that he's obtaining undue advantage out of this excessive power, then it will turn into another indictment, item of indictment. Probably that would be either abuse of office or the or passive bribery. Consequence is mandatory, so the investigation and prosecution has to establish, and in order to get conviction, court has to be persuaded that the consequence ensued, and this consequence is inflicting of damage to the rights of physical persons, and interest of legal persons, protected statutory interest of society and state. So in a sense, this is on the borderline with abuse of function and passive property as well. Let us see where it stands in the series of classification of crimes, which are 4 again, divided according to the sanctions. There are 2 types of excess of power in legislation. An ordinary or basic one is considered a less serious crime. The next one, more grave form of excessive power, is when it's done using violence or threats of this violence, or it's done with the use of weapons and other means as weapons, or they cause grave consequences. If you remember well, in my previous lecture, I mentioned to you what grave consequence is. Grave consequence allows for some room of objective and subjective evaluation, and it depends on the position, on the qualities of the affected people or affected rights, as well as it depends on the nature of the behavior, which depending on the state of the society at that stage, on the concerns of the society at that stage, it can be considered as grave. I gave you example of producing this counterfeited medication for kids, which was considered as grave at the time, although it didn't cause the actual consequences. And naturally it is the consequence of causing grave bodily harm or causing death of the affected person. The next offense which we are considering is taking on powers of official. Penal Code section 310. This kind of offense, it's in a sense it's similar to identity theft of which exists in the legislation of some other countries, but I provided to you here the direct translation of the offense. It's when ordinary person, it's like the ordinary member of society, takes on and he actually exercise power which he shouldn't or she shouldn't exercise, but this power this function belongs to a public official. So mens rea as usual, and we keep repeating this just to better remembering it. Mens rea is direct intent, as no other forms of guilt are acceptable for corruption offenses. Actus reus, perpetrated can be done by anyone except public official, because if public official does it and he needs to excess his power or abuse his power, here we're talking about these normal functions, okay, normal functions which in practice they have to be implemented by carried out or exercised by public officials, but some person is taking on these powers. Behavior has to be active action. Modus operandi, the way the crime is committed, is the person. This person he presents himself or herself as an official, and or misappropriates the powers of an official, i.e., does something which he shouldn't be doing because he's not public official. Incentive doesn't need to be established in this case, and benefit also does need to be built. There's a necessary mandatory burden of proving the infliction of significant damage to the rights of physical persons and interests of legal persons. As you can see, different from the previous previous section, there are no protected interests of society or state. This is the offense of taking powers of official. Let us see where it stands among the classification of crimes, which are 4, divided according to their sanctions. And there's only one form of this offense which is considered a less serious offense, with the sanction of up to 7 years of imprisonment. The next offense which we are going to look at our lecture today is official fraud, or fraud by official. It actually, its name can be confusing because there's also another offense in section 178 of the Penal Code, and they do not use the same terminology, but it comes to this inappropriate behavior of public official. 178 is more about a kind of swindler and general fraud, whereas here we're speaking about a specific offense when the public official is fiddling with the official documents or information sources. Mens rea intentional, direct intent, actus reus, objective element of the crime. It is committed by perpetrator, it's committed by an official through the action, active action. And modus operandi, the way how this offense is conducted, it's about inserting false information into official documents or information resources. Alternatively, it could be the amendment introduced into the content of official documents or information resources with a view to distort the content thereof. What is meant by that? Okay, what is official document? Official document is any document in our legislation, in our legal practice, which actually confers rights or prohibits certain actions, or empowers, i.e. Establishes legal consequences, or prescribes mandatory behavior for people or organizations. I would like here to remind you this decision of the Constitutional Court on the definition of public official. So it actually could be anything ranging from diploma of the university, certificate of education, up to the ID, falsified, fabricated ID of law enforcement agencies. It could be a license where the content was expired license, which was content was distorted to show that it's still in effect. And when we speak about information resources, if a couple of years ago it would be difficult to understand what information source is, now it's apparent and clear that it is about these databases which contain information about the rights and privileges and duties of citizens. into the registry on property, in a registry on registration for participation in some important event. And electronic documents are also covered, as we know that increasingly now most of the documents, they are transferred into the virtual area. So even court decisions are now first published on the websites, and then you can print them and have this code which identified, unique code which identifies it. So we are kind of living at the era when these paper-based documents are gradually being transmitted into the virtual documentation, and this definition covers it all. Incentive, it has to be with a greed. It's specifically shown here that the purpose is about greed. So that this element is present here shows that it can go hand in hand in the course of indictment and prosecution. So a person, if a public official commits some other crime with this intention, like abuse of office, he breaks the law, and also he falsifies some documents, then he will be indicted according under this both sections of 308 and 313, and the same would go to the other types of offenses as well. Beneficiary is official, and consequences, this change must take place actually. Now, let us see what's in the classification of crimes. There's only one type of this offense, and it is a crime of not big public danger. We are going now to these remaining offenses. Remaining offenses which were introduced a few years ago are 314-1, 314-2, and 314-3. They are within chapter 30 of the Penal Code, and they are classified as corruption offenses. The names and their titles are making decision on land plots belonging to the state, then assigning of land plots in violation of legislation and issuing permission for construction works, and finally failing to prevent illegal construction works. I will not go into details of these offenses for the simple reason that these offenses are specific offenses, and they were established in order to economize on the resources. That's my position. That's how I understand it, and that's how the position exists in the legal community, in order to facilitate the investigation and prosecution of people who are, again, abusing their position. It's just the specific nature of this offense which does not require law enforcement agencies establish additional elements of the offenses in order to reach conviction for the perpetrators. And also it came at the time, this legislation came at the time when there were serious concerns about the frequent occurrence of mistreatment of land plots, i.e. when the property in the country has different types of ownership. Usually it's property in state ownership or private ownership, as well as municipal ownership. So at some point in the history of modern state, there were frequent offenses in handling and treating these land plots, and this also contributed to the development of these specific provisions. in order to show the public danger and the seriousness with which a state is treating this type of offenses, and send a message to the public, specifically formulating and spelling out this type of offenses, and therefore they were introduced. There are, of course, other types of offenses in public sector, criminalized offenses in public sector, which I will speak in the next lecture. Such offenses as fraud committed by a public official, or obstruction of justice, which is provided by United Nations Convention, and it's included in this convention as well. But for now, that's it. As I promised, my lectures became shorter in order to facilitate your understanding. And I would like to complete this session going back to our slogans: stay at home, be optimistic, and don't waste your time by no means. Bye bye.